I'd like to examine a document that is not as well known as it ought to be in American history. It has a lot more importance than you would think, given how widely known they are. That is the Mecklenburg Instructions from the 1st of November, 1776. Mecklenburg today is the county in which is found the city of Charlotte. Back in 1776, it was something of a rural backwater. It was not exactly the center of American revolutionary fervor. The voters of Mecklenburg had elected members of the community to represent them in the provincial congress or general assembly. If you recall, 1776 was when the colonies had declared their independence and were in the process of winning that, of securing that. The task fell to what used to be the colonial legislatures, which resolved themselves into the state legislature and also the Constitutional Convention, to draft a new constitution for the state of North Carolina, because some of the colonies previously had had a royal charter or a colonial charter of some kind. Now all of the states needed to draft a constitution. So this was the body that was going to draft that constitution. And the people of Mecklenburg wanted to give them instructions. They wanted a couple of things. One is they wanted the state of North Carolina to affirm the Declaration of Independence. They were not changing their minds. Next, they wanted the state to form a free government with a constitution and a Bill of Rights. This is not the first time that a Bill of Rights had been discussed in English political or legal jurisprudence. In the Glorious Revolution of 1688-89, Parliament had drafted a Bill of Rights which laid out the conditions upon which they would hand the crown of England to William of Orange. And he had to agree to these rights listed in the Bill of Rights. The people of Mecklenburg also wanted the following ideas included in the Bill of Rights. Political power is of two kinds. One, principal and superior. The other, derived and inferior. So we're talking about establishing a hierarchy here. The principal supreme power is possessed by the people at large, and the derived and inferior power by the servants which they employ. This establishes very clearly who belongs to which group. Whatever persons are delegated, chosen, employed, and entrusted by the people are their servants and can possess only derived inferior power. When was the last time you talked to a government employee that you felt like you were talking to your servant and that they knew they were public servants? I'm sure there are some, but ironically, the ones that are at the federal level are probably the least likely to treat citizens as if the citizens were their masters and that they were the servants. I'm sure at the local level it's possible that when you go to pay your water bill, that the people there are nice. Whatever is constituted, ordained by the principal supreme power cannot be altered or suspended or abrogated by any other power, but the same power that ordained may alter, suspend, and abrogate its own ordinances. Now what that means is this. The people of the state or of the United States ordain or constitute make a decision on a constitution. The elected officials have no power to alter the decisions that the people made in their principal and supreme power. They can only execute what the people have decided. And so any attempt at abrogating the Constitution or amending it by just changing what you say the words mean is, in fact, improper. The rules whereby the inferior power is to be exercised are to be constituted by the principal supreme power and can be altered, suspended, and abrogated by the same and no other. Now, again, what this means is the people have decided in the Constitution that the Congress has got enumerated powers. When the Congress, in its subordinate inferior role, tries to go beyond those powers, there's going to be a problem. No authority can exist or be exercised by what shall appear to be ordained and created by the principal supreme power, or by derived inferior power which the principal supreme power hath authorized to create such authority. So, for example, the Constitution gives to the Congress the ability to build an army and maintain a navy. If the Congress goes beyond that, then there's going to be political or constitutional issues with that decision. For example, when the U.S. created the U.S. Air Force, there were people who argued that we needed to modify the Constitution because the Constitution only talks about an Army and a Navy. And while we have a great Air Force, its existence is on shaky ground. That the derived inferior power can by no construction or pretense assume or exercise a power to subvert the principal supreme power. Now, this has come to light a number of times through American history. Early in the Republic, there were constant battles on this issue. The people that were in the federal government said, well, what if we just interpret the words to mean that this is authorized, even though it's clearly not, by what the intentions of the people were in ratifying the Constitution. And this continued up until, well, the present day. Okay, so what does this mean? The people of Mecklenburg County wanted to get in writing these instructions to their delegates that were going to go and draft a state constitution. Remember, there was no federal constitution in 1776. Hadn't even been dreamed up yet. So they were instructing their delegates very clearly on certain principles. What those principles are can be boiled down to the following. The people in our system are supreme. The office holders are subordinates, and they hold power by the leave of the people. The people can alter the system, but the office holders cannot, because they have derived an inferior power. And office holders cannot, by construction, alter their rules. So, what is the significance of the Mecklenburg Instructions? The instructions were intended for delegates going to the state legislature to draft a new state constitution. I would argue that the thinking applied to the former also applies to the drafting of the federal constitution. There's nothing inherent in the instructions that would imply that. The Constitution delegates to the federal government limited enumerated powers and sets limits on the office holders who hold inferior and derived power. In thinking about the Supremacy Clause, many people today conflate the federal government and the federal Constitution. The Constitution says that the Constitution is supreme, not the federal government. If the federal government goes beyond the limits that the people in their superior and principal status have placed on it, then there's going to be a constitutional problem. The sovereignty of the people of the states. If you look at the text of Article 7, it says, and I quote, "The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same." Congress didn't ratify the Constitution. State legislatures didn't ratify the Constitution. The members of the Federal Convention, when they drafted the Constitution as a proposal and sent it to the states, the peoples of the states, for their ratification, bypassing the federal government and bypassing the state governments and going right to the people of the states as states for ratification. So where does sovereignty lie in our system? Many of the founders talked about the Senate as the place where the sovereignty of the states was represented. Now, the Constitution itself does not answer the question about where sovereignty lies. The peoples of the states, by ratifying the Constitution, had delegated powers to the federal government that only sovereign countries have. The power to engage in international affairs, the power to declare war, the power to send and receive ambassadors, etc. This is common sense. These issues in which the United States interacted with other countries of the world had to be centralized. Otherwise, you could have one state allying itself with France and another allying itself with England in the wars in Europe. And chaos would ensue within the United States. So the peoples of the states, by ratifying the Constitution, agreed that their state would not engage in international affairs, declare war, receive ambassadors. Only the federal government could do that for them because the people, in their principal and superior status, had delegated those powers to the federal government. Final issue was the Judiciary Act. The Mecklenburg Instructions lay out a political philosophy which empowers the judiciary to overrule political decisions. If Congress were to pass a law and the President signed a law making the Roman Catholic Church the official state-sponsored religion of the United States, the judiciary could strike that law down. The Constitution, ratified by the people of the states in their principal superior status, says that it is not allowed. Congressmen and presidents have derived and inferior power. The people have principal and superior power. The judiciary can strike such a law down not because the judiciary is superior to the legislature or the executive, but because the people are superior, and that they have given the power and indeed the duty of striking down unconstitutional laws. Of course, this can be taken too far. Congress claimed that the federal judiciary was the final arbiter of constitutional questions. This is a very broad interpretation of the act. If there is a conflict between the people of a state and the federal government, the Federalists said that it should be referred to the federal judiciary, but the federal judiciary is not an unbiased judge. If I have a dispute with my neighbor over a land sale and I say, it's okay, let's refer this to my wife and she will judge, then the other person can say, wait a minute, your wife is not a disinterested party. She's not a disinterested judge. She depends on your household for livelihood, and she's more likely to rule in your favor, regardless of the facts of the case or the law. The same thing applies here. The federal judiciary is part of the federal government. It has derived an inferior power in a dispute with the people of a state. Now, what I did not argue here is that certain people in one county, inside one state, rendering some opinions in 1776 is therefore binding on all peoples in all counties and all states. What I am saying is that they capture thinking about the nature of the relationship between the people, the government, and the Constitution prior to the drafting of the state constitution and also prior to the drafting of the federal constitution. These ideas ought to be more widely known.